Welcome to this recording. The person speaking right now is Cindy. I'm a staff attorney at SOAR Immigration Legal Services. Today we're going to talk about refugees and adjustment of status, also known as green card. Our offices are located in Portland and also Hillsborough. You can call at these listed times at this phone number here to get a consult with us. Also email. Okay, today we're going to be talking about what is a refugee. So we all are on the same topic. The current situation we're seeing here in Oregon and nationwide as it pertains to adjustment of status or green card. What to do if you're detained as a refugee. Actions you can take now if you have applied for green card status or you have not applied for green card status. And at the end, we'll share some referrals and resources. Okay, so first, what is a refugee? A refugee is a person who has been persecuted based on a fear or a future fear of persecution on race, religion, nationality, membership in a particular social group, or political opinion. That's the definition. A good way to know whether you are a refugee or not is if upon arrival to the United States, you were inspected at the port of entry and admitted. Usually you would have received an I-94 or a travel document. Those who have asylum or are paroled when they are entering the United States are not refugees. Usually a refugee will have permission to work and live in the United States as well. You can travel outside of the United States with something called the refugee travel document. And lastly, another thing we're going to be covering a lot today is refugees must present to USCIS or immigration to review their entry and apply for green card. Now, we're going to be covering the current situation as it pertains to a memo on refugee adjustment applications. Remember, when I say adjustment of status, I'm talking about the green card application, changing your status from refugee to green card holder, or another term that you might have heard is legal permanent resident. So the memo on refugee adjustment applications applies to refugees who are admitted from January 21st, 2021 to February 20, 2025. So if you were admitted between these two periods, these years here, these policies are talking about you, about those people who entered during that period of time. So again, January 21st, 2021 to February 20th, 2025. So this first memo, announcement, policy change that USCIS issued instructed all staff to hold or pause green card applications for refugees. It also said that USCIS will require a review and potential re-interview or second interview of all refugees. And then all refugees who entered during this time period will have their cases reviewed. So what is actually happening right now? So across the country and in Oregon, we're seeing that green card applications filed by those who are refugees and came as a refugee during these time periods, their applications have been paused or stopped. So this means the application, immigration has it, they're reviewing it, and they're potentially going to call people during that time period to be re-interviewed. And then just a general review of all of those cases. So that's how we're seeing this being rolled out right now. Now, after this announcement, another one was made also. And it's this one here that we've probably heard a lot about, the travel ban or high-risk countries. So the other policy announcement was a pause for immigration benefits from high-risk countries. So the memo is saying that immigration, USCIS, is going to be holding and reviewing applications from high-risk countries. So we're going to be seeing a slide in a minute about what countries are currently on that list. But what the memo is saying is that there will be a hold or pause on all asylum applications, on pending benefits, and a re-review of approved benefits. So let's give an example. If you have filed an asylum application, you're from a high-risk country, your application right now is paused. It will not be decided, and immigration is reviewing it. We do not know how long this pause or hold will last. But we do know that more countries are being added to it. Sometimes countries are removed from it. So what is happening right now? As I mentioned, there's a pause definitely on asylum applications for refugees, our topic today. We're really seeing that pause in naturalization ceremonies or citizenship ceremonies. So another example is a refugee already had their green card status. They apply for citizenship. Maybe they pass the exam. They're scheduled for a ceremony in which they will receive their citizenship certificate. But unfortunately, they are paused or not allowed to continue that ceremony and become a citizen. So that's how we're seeing the pause affecting refugees right now. And then, of course, as we've talked about already, the interviews required for the green card applications. We're seeing basically a mandatory review of interviews for those who entered as refugees and are applying for a green card. All right, so here's that list I was talking about. These are the high-risk countries that we're seeing that are included on that list, on that memo. Like I said, right now we're talking about February 27, 2026. That was the latest announcement of the countries included. Today's recording is being done in March 23rd. So this is the most recent information. This list could change. We have seen additions and subtractions of this list. So just letting it sit there a little longer so everyone has a chance to review, and feel free to pause the video as well. Okay, let's talk about this other memo. This is a memo that's happened in February, calling a return to custody. So remember in one of the first slides, we talked about how one of the responsibilities of a refugee is to return or report or adjust status, right? Apply for a green card application so that your admission, your entry into the country can be reviewed again. So this memo is a way to enforce that in a pretty severe way. So the memo is saying that if a refugee does not submit an application for green card status and appear for an interview after their year in the United States, they can be detained. That means if you're a refugee and you've been living in the US for more than a year and you have not applied for your green card, you could potentially be detained. We're going to talk a lot about what that means in a minute. Let's continue here. So DHS is also required to locate, arrest, and detain refugees who did not file this application and appear for an interview after a year. The interview includes revisiting the refugee claim, and refugees will be either admitted as green card holders or placed in removal proceedings. So what the memo is saying is that if someone has not applied for their green card application, they're a refugee and it's been over a year, immigration, ICE enforcement, they have authority to conduct searches, arrests, and detain refugees in this kind of class in order for them to comply with the returning to custody, comply with the process of having their admission reviewed. But what's actually happening right now? So after this memo came out, there was a very targeted enforcement happening in Minnesota and refugees in that area. We did see the transferring of approximately 100 refugees to detention centers in Texas. Afterwards, there was a litigation or a court order that led to their release. So refugees who were in that situation were released. And then after, in February 18th, we have seen interviews scheduled still, but what we're seeing is it's a typical notice to come to the immigration office, do your interview there, and then that's the end of the process. We're not seeing a detainment or arrest after such interviews. So that decision by a court really halted some of what we're seeing in this memo, some of the things that USCIS claims they have power to do or ICE says that they can do. And so even though we're not seeing the type of enforcement action we saw in Minnesota in February, it's still good to talk a little bit about Know Your Rights. So I know talking about being detained, possibly put in removal proceedings can be alarming. So let's talk a little bit about what it means to be prepared for something like a detention. So your rights. When we talk about exercising your rights when you're encountering ICE or immigration enforcement, we need to understand where are we when this happens. So there are two types of spaces that your rights interact differently. So if you're in public, so we're talking a parking lot, a grocery store, somewhere where people can come and go and you don't need special access or permission to be in, right? Those are public spaces. And our rights are different there, meaning that immigration doesn't need permission to enter those places initially. And so they can exist in those areas as any other member of the public can. Now, private spaces are different. So this would be any area where someone cannot enter without permission. So maybe at your work, it could be the break room, right? Customers, people of the public cannot just come into the break room without permission. It could also mean inside your employer's factory or areas that are meant for storage and are off limits to people from the public. So entry to those spaces will require what we talk about, what we call, sorry, a warrant, a search warrant, or consent. So let's remember this because we're going to come back to it. A judicial warrant, we're going to see in the next slide, is a piece of paper that gives permission, essentially. Now, the other thing says consent, right? Consent means saying yes to something. So if immigration is allowed to come into a space, then you have given consent, which then lets them enter these generally private spaces without the warrant. So let's talk about first the warrant, judicial warrant. So here we have some images. On the left is the judicial warrant. And the way we know that it's a judicial warrant is because it's going to say court on it. So you can see here it says United States District Court. So that's the first thing you want to look for, that this is from a court and not from security, from ICE, immigration. That is not judicial. Judicial means that a judge, a court, has decided that this person, ICE enforcement, is allowed to enter this space. So it's always going to be a court. You're always going to see that word there. And then you want to look, who is it that they say they're searching and what is their address, right? If the name that you're seeing on there is not your name, not your home address, then they do not have permission to enter this space, even though it says court, even if it is signed. So usually we're going to be looking for the words court, the name and the address of where they're saying they can search, and then a signature from a judge. Now, on the right, this looks pretty official as well, right? So it says U.S. Department of Homeland Security. It says warrant arrest of an alien. So we talked about warrants. We talked about that it has to be signed. So this one already we can tell, right, that it doesn't say court. It doesn't have a name of somebody and their address. And maybe it's signed, but it's not signed by a judge. So this is an administrative warrant, and it is not going to be enforceable to enter your home, for example, or a business. Okay, so we've talked about public and private spaces, and we talked about what a warrant looks like, a judicial warrant. Now, earlier I also told everybody to pay attention when I said consent, right? So in some instances, if we say yes, we give permission for enforcement to enter an area that is usually private, they do not need that warrant. And that's why we say, that's why we're practicing our rights right now, right? That we do not have to give consent permission to enter an area if there's not a warrant. So in the place that this will usually come up is in your home, right? Your home, whether you're a renter or you own your home, you have very strong protections and rights in your home. No one is allowed to enter your home without a judicial warrant. If someone comes to your home, knocks on the door, says they need to come in, you can say, well, first, you don't even need to open the door, but you can say that you do not wish for them to enter that you will not answer any questions. You're going to remain silent. This slideshow here says to pass a red card underneath the door and do not open the door. So a red card is, maybe you're familiar with it, is a card that kind of has an explanation of your rights, and it has statements saying, I do not consent to a search, I do not wish to speak with you, I'm going to remain silent. Those are statements that you can make, maybe through an open window, or maybe just putting that card on a window and letting the person read it. But do not open the door, because sometimes opening the door can be seen as consent or permission to enter the home, although it's not that. It's not permission just to open the door and see who's there. It can be interpreted that way, and so the safest option is to not open the door, but still exercise your rights and say that you're not going to be speaking or answering any questions, and that you will not be letting them into your home, right? It also instructs here to call an attorney and that you have the right to film. So let's kind of talk out the situation. Someone comes, knocks on your door. Let's say they say, I have permission to come inside. I'm looking, let's say they say your name. First, you would ask, right? You would not open the door, maybe through open window or shouting through your door. You would say, do you have a warrant? Maybe they show you a piece of paper, but it doesn't say court on it. It doesn't have a signature by a judge. And maybe they said your name, but your name's not on that piece of paper, right? So if it doesn't pass any of those that fail, you do not need to open the door, right? So you say, no, I'm going to exercise my right to remain silent. I'm not opening the door. I don't wish to speak with you. And at this point, you could film the interaction. You could call an attorney. You can also call PIRC, which we're going to talk about at the end of the slideshow, in order to report that there is ICE or immigration enforcement happening, right, in your neighborhood. So those are steps you would take in your home where you have the strongest protection, where that judicial warrant and your consent come into play. Let's talk about a different situation in your car. So we have seen a lot of enforcement actions happening in this way in your car, and this is usually because in your car you have less protections than you would in your home, right? And it's easier to conduct a traffic stop than it is to get permission to enter someone's home. So your car can be stopped if there's reasonable suspicion. This is usually when maybe you're driving a little too fast, you ran a red light or something, and the police officer can't stop your vehicle because they are suspecting that you violated a traffic law. And maybe all of us know that when that happens, you have to show your driver's license, proof of registration, and insurance. But what's important to note here is that the passenger actually does not need to provide any identification. Now, there is also a right to object to search of your vehicle. So it's still, like we talked about in your home, you still need to have, the officer still needs to have permission to search your car if there's no reasonable suspicion that something is wrong, right? If you get stopped just for going a little too fast and they say, we want to look in your car now, you could say, no, I do not consent. I do not agree. I don't give permission. And that would be your right. And if that was violated, you can then complain about that. Now, when ICE is involved, there is kind of a rule saying right now, a safety rule saying that they are allowed to ask you to get out of your vehicle because it's unsafe for them to make this kind of stop with you in a running car. That could be debated about the legality of that. But what we are advising you is that that is a possibility, but that doesn't mean your other rights go away. You still have the right to remain silent. You still have the right to not consent to a search. And only the driver would have to show their license registration or just your identification. Let's talk about a different situation, your rights at work. So this one is different as well because maybe a lot of us work in places that have public areas but also private areas, right? So maybe the customers can come up to the lobby area, but they can't access your break room. So in this type of situation, there should be some kind of safety plan with your boss about which areas are going to be off limits, which areas are going to say are private and that cannot be entered. So that way there is a safe area at your work. Now, ways that you can do this is consider posting signs indicating private spaces, and of course, having a safety plan with your boss or your fellow employees. Now, just because you're at work now doesn't mean those other rights go away. The rights we talked about remaining silent, not consenting to a search, and asking for attorney. Those rights remain anywhere you are. What's changing each time in the scenario is whether there needs to be something that is signed by a judge, right, to enter the space. And remember that consent is always in the background. With giving consent, then there needs not be a warrant, and you're agreeing, right, to some kind of search. Now, at the end of this slide here, it's also saying that it's advising you not to run. So running can give reasonable suspicion, which means it can make the officer think that maybe you're violating a law if you run. Now, maybe we disagree with that, but that is something that can give permission for ICE to chase you or to detain you simply for running. All right, so here's a list of phrases that cover all of the rights we talked about and are good phrases to practice. So, am I free to leave, right? So this one, we're asking if we have to remain detained. Am I free to leave? Can I leave? When you say this one and the answer is yes, you should calmly walk away. You can also repeat any of these phrases as many times as you need to until you get an answer or until your rights are respected. And, maybe we're thinking around, well, what if none of these rights are respected? Part of the point of our rights is to be able to not consent and later be able to file a civil complaint or maybe liberate ourselves from a detention area because our rights are violated, right? So sometimes rights will kick in later. Later, they'll become more important than they are right now. All right. Another phrase to practice is I do not consent to a search. So this is right, our right to not be searched without our consent, without a warrant. So I do not consent to a search. Do not want to answer any of your questions. So this is a phrase you can use to exercise your right to remain silent. So sometimes if you say, I wish to remain silent, I don't want to talk to you, I don't want to answer your questions, officers may still ask you questions. You can keep repeating this phrase over and over again. Another one is, I want to speak with a lawyer. So in a situation where you're arrested, you do have the right to speak with a lawyer, an attorney, and this is something that you, in the immigration context, you will not be assigned an attorney. That is not a right you have, but you do have a right to speak with an attorney, which could mean calling a family member to arrange a meeting with your attorney, or if you have an attorney that you've hired, calling them. All right. So now we've covered some of our rights. We've talked about all these announcements, policy decisions that immigration has made in these recent months. Now, what does that mean for our particular situations, right? So what if our situation is that the person is a refugee, they have not applied for green card status. So what should they be doing now? So you should apply for green card status because the rules right now are saying that you can be detained or you can be brought in, called in, right, in order to check if your admission was valid. And so if you apply for your green card application, you are consenting, or sorry, you are initiating that process, right? You are agreeing to file your application, and you're following along with what the rules are. And so our understanding is that this is still the best course of action if you have not, because you are complying with the law, and you have your application turned in so it can be reviewed. And so when you're called in a situation where you're re-interviewed or you're interviewed, you haven't violated any rules, right? So you're ready to go. So you should always meet with an attorney to file this application, especially now because part of the application process is going to be reviewing your reason that you are a refugee, right? What kind of persecution did you face in your home country that made you have to leave? And so sometimes your attorney may suggest that you gather paperwork from that time, or will practice with you questions that you had during your first refugee interview at the refugee camp, and let you know any risks that you're taking with applying for the green card or not applying for the green card. Okay, so maybe applying for something could also mean it could be denied, right? So what does that mean to termination or to be denied? So if immigration finds that when you entered the United States at time of your admission entry, that you actually were not a refugee, that you did not meet that definition we discussed at the beginning, they can decide to terminate your status, and you will receive notice of this, and you'll have a chance to fight this claim, right, in front of a judge. So that is why it's important to get an immigration attorney to help you file your application, to kind of catch these issues beforehand, and maybe they can be ready to go with this kind of argument, and if they believe that you could face a negative decision. All right. What if your situation is that you already applied for your green card, but you are a refugee that entered during that time period we discussed earlier, and so you're worried that you're going to be interviewed again, or that you'll be interviewed for the first time when maybe you applied, they told you that interviews were rare, but now everyone's being interviewed for this type of application. So what you should do is hopefully you have a copy of your application, or an immigration attorney can help you request a copy of your application or a file. And then that way you can review that application and practice the answers you provided on your application and questions that will be asked during your application, during your interview. So if you are terminated, just like we discussed earlier, if your application is denied, it is possible that a result will happen that we discussed, that you could be denied and then go up to a judge to see if you can still be remain in the United States as a green card holder, make an argument in your favor. But sometimes what can happen too is if you have recent criminal history, this can be a different reason for denying your application, right? So one reason we talked about denying your application is that when you entered the United States, you did not meet the definition of refugee. Maybe your claim was not valid. The second reason we're talking about is if you have certain crimes or you've committed fraud. And so if your application is already pending, it's very important to speak with an attorney to see if any of these reasons apply for you, because then you need to be prepared for that questioning at your interview and be prepared for what might come after as well. All right, so we've talked about all these changes that have happened. We've talked about how to exercise our rights in case there's a detention, and what to do if you've applied or not applied. But how do we even get started on taking all these steps, right? So scheduling a consult is the first step. And you should always speak with an attorney or a accredited representative when you're asking questions about your immigration status or your applications. So how do we know if the person we're talking to is actually an attorney? So every attorney is required to be registered at a bar or bar organization. This is like a organization that monitors attorneys, all kinds of attorneys. And it's also a way that you can report any, violations or bad behavior of an attorney if they are doing something illegal or criminal against you, right? It's also a way that you can look up your attorney. So if you search online for your attorney, you should be able to find them in a directory. So you're in your consultation, right? You ask the attorney, where are you registered as an attorney? The attorney tells you Oregon. You should be able to very easily search online Oregon State Bar. There will be a directory of attorneys. You should be able to put the name of that attorney and they should pop up. If they do not pop on that list, if they don't come up, it's possible that they're not an attorney in that state or they're not an attorney at all. So make sure to ask anyone you're in consultation with what state they are registered in as an attorney. Sometimes you might be speaking to an accredited representative. So only in the immigration context are there representatives that are accredited by an organization. And they're accredited to very specifically help with immigration matters. And so, usually, the sponsoring organization is going to be a nonprofit organization. For example, SOAR, we have accredited representatives, and these accredited representatives also appear on a registry, on a list. And so, their names should pop up. Another way to also verify is to ask the organization if they are accredited, or ask the person, who do you work for? What organization is sponsoring you? And if they say they don't work with any organization, then they cannot be an accredited representative, because all accredited representatives have to be sponsored by an organization. So then that could be a way to know they're not a true representative. All right, so we made sure that the person we're talking to is actually an attorney or accredited representative. The next thing is scheduling your consult. We will have resources about how to schedule with us for some of our free consultations. But remember, you can always call or email us and we can give you that information or schedule you for a paid consult at our offices. So once you schedule your consult, the way you need to prepare, especially as a refugee and these new policy changes, is to remember your refugee claim, the things you talked to the officers at the refugee camp about why you needed to leave your home country, because you were unsafe or you were afraid that something would happen to you. And so have that ready and have all paperwork ready as well. Paperwork you filed, paperwork you got when you entered the United States, if you still have that. Anything that is relevant to your refugee claim, have that ready. All right, so at your consult, you're going to discuss, applying for green card application or preparing for the green card interview. Other things you should also discuss with the attorney is any information on detention practices that are happening and safety planning. So the great thing about a consult is that it's also a chance to ask if anything has changed. So this presentation we're giving in March of 2026. By the time you are talking to an attorney, it might be sometime in the future, could be months from now. And so it's a good idea to ask if there are any new changes that you should be aware of. All right. And lastly, something to keep in mind is that there are immigration attorneys that practice the law and can represent you at the immigration offices, at your immigration interview. But if you are detained or your case is terminated or denied and you're referred to the immigration court, this same attorney may not be able to represent you at that level. So it's always important to ask the attorney you're consulting with before you hire them if they are going to be able to represent you at the immigration court and the immigration office, or if they're only going to be able to represent you at the immigration office. So all attorneys can represent the immigration office, but not all attorneys can represent the immigration court. So it's a good idea to ask, always. And we will also, in our resources, have a list of immigration attorneys that can definitely represent at the immigration court. All right, so let's talk a little bit about that safety planning. So when we say safety planning, we're talking about things you should do to prepare yourself and family members in case someone is detained. So you should pick somebody to share documents with that can identify you if you need to be represented if you're detained. If they need to get a hold of you and be able to identify you by your immigration details, right? Your name and what's called the A number. It's a number that appears in all the immigration documents that starts with A. All right, so pick somebody that's a family member, someone that you trust and don't believe would share your documents without your permission. It's a good idea to pick somebody that has immigration status, preferably a citizen. And this is because in the areas that you could be detained or places that you could appear, there could be a lot of immigration enforcement presence there, ICE presence. And so it's important that this person that's helping is able to arrive to these places and not worry about their own safety. If you're having to rely on somebody that has no immigration status, or maybe they also are a refugee that is applying for a green card, or not a citizen yet, that is okay. Give them phone numbers of your attorney. There are other ways that they can contact people to help you that won't require their physical presence. There's video calls, phone calls that you can do when someone is detained, and we'll have all that information available on the website as well. Okay, so we talked about picking somebody, considering if they have status or not. What should you actually be sharing with them? A copy of your ID, your state ID, your federal ID, right? Which is usually the employment authorization document, the card that they give you, that immigration gives you, that you can show your employer. Any copies of your I-94. So that's a document that kind of listed your first entry that you entered with RE or refugee status. So all those documents, it's good to have a copy of that to be able to prove your name, your status with immigration, and that you are a refugee. Copies of receipts or filed applications. So if you already filed for a green card application and they mailed you a receipt or have a copy of their application, it's good to share that with somebody so you can prove you have filed and you've complied with the law. All right. Copies of any court documents. For example, if you were referred to immigration court after termination of your status or referral for termination of your status, a denial, it's good to keep those court documents as well, so that they can also show that you've complied with the court process. And then, of course, any phone numbers of your attorney, family members, or other people that could be interested in your whereabouts. And any documents you should not share. Try not to share any like drafts of applications, so things that were not filed, but you were maybe just jotting down notes or information, because these documents could be inaccurate or not correct. And so you don't want to share anything like that that could confuse someone that's looking at these documents, because these documents, sharing them with a family member or someone you trust, usually means they're going to share it with an attorney or even share it with enforcement. And so we want to make sure that all documents are accurate and true. Okay, so let's talk about locating a loved one. So if someone is detained, how do we know where they are, right? We hear about people getting transferred very quickly. Here in Oregon, the person would be transferred to McAdam, which is a facility in Portland. And then after that, they would be sent to Tacoma Detention Center, which is a detention center in Washington. And after that, a lot of people are transferred to different places around the country. And so some ways to look is ICE has an online detainee locator to see who's detained. So you could search there first. You could call EOIR, which is an automated case information system, and to see if they're in the court process. You can search EOIR, automated case information system, and the number will pop up, but we'll also have that resource on the website. Another place you can call is the facility Tacoma, the one we talked about up in Washington. Those are some phone numbers you can call, leave a voicemail, and they will call you back. Now, a lot of the times when we find out about who's being detained, it's usually community reporting, community organizations that are monitoring ICE. And so PIRC, we talked about them earlier. They're someone you can call to report that a detention is happening or report that someone has been detained, and they can quickly connect you with legal representation, and also kind of create like a database of where ICE is, who's being detained, so that so community members, family members can find out where people are. And sometimes that's how people find out too who's been detained. So a good resource to have, and there's their phone number. Good idea to save it in your phone. Luz is also works with PIRC, and they do alerts of ICE presence in Salem. Centro de Servicios para Campesinos, that is CSC, yeah. They're in Woodburn, and they do similar ICE alerts. And all of these organizations will also sometimes post like cars or property that's been left behind, so that can be collected. Now, lastly, LULAC's hotline is a hotline for Southwest Washington, so Vancouver area. If the detention occurs in Washington or if your loved one is in the Tacoma Detention Center, so Washington, it's a good idea to call WAISN. They would be best able to assist you in that kind of situation, and they also could offer help with arrangements for payment to help your loved one be released from detention. So what I'm talking about there is sometimes when you're detained and you're eligible to be released, there still has to be some kind of payment made so that you can be released. And this is kind of like you guaranteeing that you're going to comply with following up with the court and complying with your case outside of detention. So usually there is a payment that has to occur, and that organization can help with that payment. All right, so the last thing is all the referrals and resources we've been discussing. So we talked about, the list of immigration attorneys that can help in court and Office of Immigration. We'll have that list there on the website. The Tacoma Detention Center guide. So PIRC made a guide about the detention center up in Washington that has a lot of information on how to video chat, phone call your loved one, also how to send money for them to be able to buy food, water, toiletries, other things they may need. So definitely check that guide out and be familiar with it. PIRC also has a Know Your Rights training that you can check out there too to learn more about how to exercise your rights. They also have like weekly updates they do if you want to, stay in touch with different policy changes. And lastly, we'll have a copy of this slideshow and all the resources we shared here in your language so that you're able to access that and share it. So thank you for listening to this presentation and check out all the resources on our page.